Appropriation and Realignment. An appropriation law is a statute, the primary and specific purpose of which is to authorize the release of public funds from the Treasury, on whom vested. The spending power, called by James Madison as the power of the purse, belongs to the Congress, subject only to the veto power of the President. What is the scope of the power of appropriation? The power of appropriation carries with it the power to specify the project or activity to be funded under the appropriation law. Hence, in the case of Philippine Constitution Association versus Enriquez, the Supreme Court ruled that there was no encroachment by the legislature on the executive power when the members of the Congress proposed and identified the projects to be funded by the Countrywide Development Fund. While it is the President who proposes the budget, still, the final say on the matter of appropriation is lodged in Congress. Need for appropriation. No money shall be paid out of the Treasury except in pursuance of an appropriation made by law. The existence of appropriations and the availability of funds are indispensable requisites to or conditions sine qua non for the execution of government contracts. Classification. General Appropriation Law. A general appropriation law is passed annually. It is intended to provide for the financial operations of the entire government during one fiscal period. Constitutional limitations. Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. No provision or enactment shall be embraced unless it relates specifically to some particular appropriation therein. Any such provision or enactment shall be limited in its operation to the appropriation to which it relates. This is intended to prevent riders or irrelevant provisions included in the bill to ensure its approval. Procedure for approving appropriations for Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. This is intended to prevent sub rosa appropriation by Congress. Prohibition against transfer of appropriations. No law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may by law be authorized to augment any item in the general appropriation law for their respective offices from savings in other items of their respective appropriations. Also, other constitutional limitations include prohibition against appropriations for sectarian benefit. Automatic reappropriation. If by the end of any fiscal year, the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by the Congress. Another classification is the Special Appropriation Law. It is designed for a specific purpose. Constitutional limitations include: it must specify the public purpose for which the sum is intended. It must be supported by funds actually available as certified to by the National Treasurer or to be raised by a corresponding revenue proposal included therein. Impoundment. What is impoundment? It is the refusal by the President, for whatever reason, to spend funds made available by Congress. It is the failure to spend or obligate budget authority of any type. This power of the President is derived from Section 38 of the Administrative Code of 1987 on suspension. How about realignment? On the constitutionality of a special provision in the 1994 General Appropriations Act, which allows a member of Congress to realign his allocation for operation expenses to any other expense category. The Supreme Court, in Philippine Constitution Association versus Enriquez, said that the members of Congress only determine the necessity of the realignment of savings in the allotments for their operational expenses because they are in the best position to do so, being knowledgeable of the savings available in some items of the operational expenses, and which items need augmentation. However, it is the Senate President or the Speaker of the House of Representatives, as the case may be, who shall approve the realignment. Hence, the special provision adverted to is not unconstitutional.